So this is acquisition of membership. Acquisition of membership. How do we become members of a company? The first way, this can be seen as one of the original ways of becoming a member of a company, is by subscribing to the memorandum. This is the memorandum of association of the company. That persons who are the subscribers to the memorandum of the company, once the company is registered, they become the first members of the company once their names are entered into the register of members of the company. The second way of acquiring membership is by way of allotment. It's by way of allotment of shares. This is where we have a company that is selling the shares to persons. It could be, if this is a public company, it is a public issue of shares. So members have bought shares in this company, and the company is allocating. The company is apportioning specific number of shares to these applicants for shares. So by reason of that allotment, the allottees, as we call them, will be becoming members of this company when their names are entered into the register of members as a member of this company. The other possible way of becoming members is by way of a transfer. A transfer of shares is by way of a transfer of shares. This is shares. This is where we have a willful purchaser and a willing seller for shares. So one person who currently owns shares in a company is selling. So to this buyer, to this purchaser, to this transferee, they will be becoming members of this company in respect of the bought shares, the transferred shares, once their names are entered into the register of members. The other possibility is by way of transmission by death. Now, this is similar to method number 5, which is transmission by bankruptcy. Transmission by bankruptcy. Now, the difference between the transfer and the transmissions is that the transfer happens willfully. The transmissions is involuntary. That the person receiving the shares is not receiving them because of a voluntary act. That this happens once we die. That our shares are passing on to the personal representative. That we have been declared bankrupt. Our shares are passing on to the trustee in bankruptcy. Now, that trustee in bankruptcy and the personal representative in death, they will be becoming members of this company in respect of the shares of the dead member or the bankrupt member when their names are entered into the register of members as members of this company. The other possibility may result from directors' share qualification. Directors' share qualifications. We have some companies that require that persons who have been proposed or have been appointed as directors should take up a minimum number of shares. Some show of loyalty. Now that minimum number of shares is what we're referring to as the share qualification. So once these directors take up this specified number of shares, they become members of this company in respect of those shares once their names are entered into the register of members as a member. Now you notice something. Since membership is a question of fact, your name being entered into the register of members, in all these methods we are describing acquisition of membership, for examination purposes, we must end by noting that the subscribers become members once their names are entered. Allottees become members once their names are entered. Transferees become members once the name is entered. In all these cases, we must bring out that aspect. Membership is only acquired by any of these methods once the name is entered into the register of members. Now that we have acquired membership by any of these methods, we also want to look at the possibilities of losing membership. How do we cease to be members of a company? Cessation of membership. Cessation of membership. Cessation of membership. Cessation of membership in a company. So some of these methods by which we acquired membership could also be some of the methods we could be losing membership by. For instance, if you look at a method such as transfer of shares, we become members once we are the transferees. We could also be losing membership by reason of a transfer of shares. Now, this has to be a total transfer of shares. So if I am currently a member of a company in respect of some 200 shares that I have, once I transfer all my 200 shares and my name is removed from the register in favor of the transferee, then as a result of that transfer, then I cease being a member of the company. You could also look at transmission by death and transmission by bankruptcy, so that we are saying these are also possibilities of ceasing being a member. Transmission by death. We could also have transmission by bankruptcy. Transmission by bankruptcy. So this is affecting the deceased person and the person declared bankrupt, that once we die and our shares are transmitted or passed on to the personal representative in death, then the deceased member ceases to be a member of the company. Once we have been declared bankrupt and our shares are transmitted, passed on to the trustee in bankruptcy, then the member declared bankrupt ceases to be a member of the company. Then we have other ways that we could also look at. For instance, we could have what you call a forfeiture of shares. Forfeiture of shares. This is usually taking up the shares of a member by the company for non-payment of a call. So where a member has some amounts outstanding on their shares and the company demands that we pay some or the whole of that outstanding balance on the shares we have taken up, when we don't pay such amounts, one of the consequences we face is that the company can take up our shares. The company may be allowed by the articles to forfeit our shares. As a consequence of that forfeiture, then we may cease being members in respect of the forfeited shares. It is also possible to have a sale of shares in exercise of a lien. Sale of shares in exercise of a lien. A lien is some form of interest we create in favor of a third party on our shares. For instance, since our shares represent property rights, we could borrow money with our shares as security. Now, once we do that, we have created a lien on our shares in favor of the lender. As you may be aware, one of the consequences of non-payment of such borrowed amounts is that the security given, in this case the shares, they may be sold. They may be taken over by the lender to satisfy the amount of debt outstanding. In such a case, when our shares are sold in respect of that lien, in respect of the security we had given in our shares, then we lose those shares. We cease to be members in respect of those shares that had or that will be sold in respect of a lien that they secure. It is also possible to lose membership by way of redemption of shares, by way of redemption of shares. So redemption is the idea of a company buying our shares, a company purchasing our shares. Now, if the sort of shares we hold give the company rights to buy them back, to redeem them, then the fact of redemption will cause a cessation of membership in respect of the redeemed shares. Then you would also be imagining this liquidation of the company, winding up of the company. When the company's existence is brought to an end, when the company ceases to exist, then our membership in that company also ceases. You will not be a member of an non-existent company.